We expect a closed police internal investigation to be the definitive record of what happened. When Internal Affairs signs off on a report, they tell the public the facts are checked, and the final word is objective truth. But on July 17, 2023, Lonnie Lupardus was arrested at his own home by Olathe, Kansas police officers. His alleged crime? Sending legal documents to an opposing party regarding an ongoing civil case. When Lupardus filed a formal complaint, Olathe Police Captain Carl Anderson conducted the internal review. Anderson issued a written disposition clearing the officers, concluding the arrest was a lawful execution of law enforcement powers, aligning perfectly with department policy. That written conclusion is completely false. To prove it, we are going to cross-examine Captain Anderson's official investigation against 3 specific pillars of objective evidence. When a department's final investigative word is a verifiable lie, the internal review process shields the department from the very scrutiny it was designed to provide. To evaluate Captain Anderson's conclusion, we have to look at the baseline assumption used by the officers on the scene. They believed Lupardus violated a protective order by sending emails to the protected party, assuming the order mandated absolutely zero contact. This diagram shows how the police interpreted the situation, treating the no-contact order as a solid red wall that blocked all communication. But under Kansas law, specifically KSA 6031A06G, protective orders have strict statutory exceptions. That statute explicitly states a protective order cannot prevent a pro se defendant, someone representing themselves without an attorney, from sending the plaintiff copies of legal pleadings. The law literally creates a bypass for court-related documents, overriding the general rule. Internal correspondence confirms that during his review, Captain Anderson was explicitly aware of this exact statute. He identified the law and knew Lupardus was acting pro se, yet Anderson completely omitted this legal exception from his final report. He chose to analyze the officer's actions as if the statute didn't exist, forcing a conclusion that the arrest was lawful. Administrative reviews are designed to measure officer conduct against the law. Deciding to ignore controlling state law to validate an arrest is the deliberate concealment of defective police work. In his disposition letter, Captain Anderson stated his findings were based on a thorough review of the audio and video recordings, as well as the officers' generated reports. The body cam footage recorded at the scene tells a very different story. While discussing the emails Lupardus sent, the arresting officers are recorded acknowledging that the communications were, quote, like a subpoena to the court or like an attorney would send to the other party. This typographic layout of the official arrest affidavit confirms it. The responding officer swore under oath that the emails were professional in manner and strictly regarding court. The officers knew in real time that these were legal communications. They recognized the nature of the emails, discussed it on camera, and then decided to put Lupardus in handcuffs anyway. Olathe Police Department Policy 111 prohibits untruthfulness, explicitly defining the omission of material information or the use of half-truths as a severe violation. By excising the officer's real-time admissions from his final analysis, Captain Anderson submitted a materially incomplete report. By burying this exculpatory evidence, Anderson failed his duty to conduct a fair administrative review. He allowed a prosecution to move forward based on an arrest that objectively lacked probable cause. To recap, Captain Anderson put in writing that the Olathe Police Department stood by the incident as a lawful execution of law enforcement powers. 10 months later, on August 23, 2024, the circumstances of the arrest were reviewed in court by District Court Judge Thomas M. Sutherland. Looking at the transcript of that hearing, Judge Sutherland reviewed the facts and stated on the record that the arrest did not technically comply with Kansas arrest statutes. The judicial system dismantled their position. Following the judge's findings, the district attorney dismissed the case entirely, and the court ordered a full expungement. We have an internal affairs captain officially declaring an arrest lawful, while a district court judge reviews the exact same facts and rules that it violated state law. This is what it looks like when a department prioritizes institutional protection and civil liability over factual accuracy. The official narrative has collapsed. Kansas law explicitly permitted the emails. The body cam proves the arresting officers knew the emails were court-related, and a district court judge ultimately ruled the arrest was illegal. Captain Anderson's disposition represents a deliberate institutional ratification of police misconduct. The city manager and the Olathe City Council have the record. The necessary next steps are clear. Rescind the erroneous findings, assign an independent investigation outside this chain of command, and hold the department accountable to the laws they are sworn to enforce.